Stanley's success system is to get the maximum award. That means accident investigation, medical investigation, means hiring expert witnesses and guiding the client to the proper steps that they need to take. Everybody working together as a team over time to understand what needs to be done so that we're all successful, to make sure that we cover every base, to leave no stone unturned. Stanley Law, the maximum award people. A driver doesn't see you on that e-bike. A worker falls from scaffolding. A car crash at a stoplight turns into a lifelong injury. These aren't rare stories. They're happening every single day. So the question is, if it happened to you, would you know what to do next? I'm Joe Stanley with That's the Law. E-bike accidents. Well, these are a very, very common situation that we have this day. Everybody sees them or doesn't see them, as the case may be. If the e-bike driver hits you or they hit you and you're on an e-bike, the answer is almost always going to be, I didn't see them, or they were in the wrong place. They were going the wrong direction. They were going too fast. Those are scenarios that come up every time. And unfortunately, you're riding an e-bike and you're being pitted against a driver. You have several strikes against you, both from a logistics point of view and a legal point of view. And let's talk about that. Because, okay, you're on an e-bike, and even if you're operating it following the rules of the road, drivers are going to have a hard time seeing you and dealing with you, okay? And if there is a collision, you usually come out on the wrong end of the stick. But e-bikes, just like motorcycles, when you're pitted in the courtroom against a driver, you're in a very, very small minority. Everybody drives. You can assume that you're going to be judged by a jury. Almost everybody on that jury drives, and they probably almost all drive a car. And they almost all have experienced motorcycles and or e-bikes, probably not in a favorable way. So, how do you overcome that? How do you deal with that? That's an implicit bias, is what we lawyers say. There is almost everybody you're going to be dealing with, from the insurance company rep to the people on the jury. Even if you did absolutely nothing wrong, there's going to be something in the back of their mind saying, wait a minute, this e-bike drivers, they're all crazy. They're all riding around too fast on the sidewalks, going through stop signs, red lights, not paying attention to anything. Same with the motorcycles. So how do you overcome that? Well, you overcome that, A, by making sure you follow the rules of the road, okay? They're making sure that you weren't at fault. And then it's investigation that's critically important for these kind of accidents. There's a lot of video out there, and maybe there's even video in the car or the cars that were involved in the situation, because it's very important to establish what the actual facts were of the accident so that you, who are the injured person who wasn't doing anything, just because you were on an e-bike doesn't mean you are treated differently. So that's how you have to overcome these implicit biases. You show them that here's what happened. And this person could have been on a bicycle, they could have been walking, they could have been doing anything, but they were doing it legally, and the person who was operating the vehicle, the car, the truck, whatever, didn't see what they were supposed to see. That's what is absolutely necessary. So not as easy as it sounds either, because there are still some scenarios where it's your word against their word. And the only way you can really then come down with a plausible means of demonstrating you were doing the right thing is by accident reconstruction, which is complex, expensive, and sometimes doesn't give you a conclusive answer anyways. And then we can talk about that in the future, accident investigation and reconstruction, whether it's by AI or just regular going out there and taking measurements. It can be important, it can be useful, but it may not necessarily demonstrate what you need to demonstrate in every case. Okay? But just remember, if you're hurt on an e-bike, you have the same rights as anybody else. You're to the same legal protections. And by the way, we talked about an implicit bias in this situation. Well, I'm sure as we'll go along, we'll talk about many other implicit biases and other psychological factors that come in play with people who have been involved in personal injury cases that can affect your rights, whether you like it or not. A worker falls 30 feet on a construction site. But the real question is, who's actually responsible? And that is a very, very good question. And is it always the employer's fault, or could it be someone else's fault entirely? Well, I can explain that, and let me explain. In a very, very complicated scenario, the answer is yes. Others can and are responsible for construction site safety. Now, we're going to talk about how that works. New York has special rules that imposes vicarious liability, magical word, on owners and general contractors for specific construction type activities. Now, what do you say vicarious liability means? It means they are responsible by statute in situations where they normally would not be so, regardless of whether they were actually there or participated in the actual accident situation. And you may have heard over the years people in the construction trade and insurance companies complaining that it's not fair to impose this type of liability on owners and contractors to keep construction sites safe because they aren't really doing anything. Well, they are doing something. They are making lots of money, and they are hiring the people to build these projects that make them lots of money. And the purpose of the statute was to ensure that the people who are making lots of money are responsible for ensuring the safety of the people that do all the hard work on the construction site. So if you get hurt on a construction site and you're engaged in one of these enumerated activities, which we could spend days talking about, you are covered under that law in addition to whatever workers' compensation pays. Now, you say, does that really matter? Well, let me explain that. Workers' comp is limited in time and money that you can ever receive, all right? It is not meant to replace all of the damages you suffered as a result of an injury. It's just not. It's meant to provide a means of fair compensation to get the worker back in the workplace. But there is no assurance that those payments are ever going to equate with what your actual injuries are. So that is the reason why you always would want to investigate whether or not a third party is involved in a construction site accident or for that matter, in any other kind of accident involving a workers' compensation injury. But right now, we're just talking about construction. All right. So in a construction case, you fall off a scaffold and you break a leg. We'll leave it at that. You are entitled to workers' compensation benefits that are limited in time and place. All right. But in addition to that, if you investigate it and can show that the owner and the general contractor were involved in your situation, then you have a personal injury claim against them for all of your damages. Now, your claim includes all the payments that workers' compensation pays. So there is no overlap in the payments. And what does that mean? That means that workers' compensation gives you a payment. You sue a contractor or an owner. You sue for what you receive from workers' compensation, but you have to pay them back. So there's no double recovery. Ultimately, you and your workers' compensation carrier are in the same side, which is unusual, I'm sure. You're not usually on the same side very often. But in this situation, you're both on the same side because they want to get paid back. Maybe. And I say that's a big maybe because in construction cases, and we'll leave it at this, and we could talk about this, it's fascinating. But ultimately, what happens in almost every construction case is that because of contracts or because of the actual legal responsibilities, the insurance company for the employer, who may or may not be the same insurance company who paid workers' compensation, is ultimately going to be the one who pays out any personal injury judgment or settlement. Now, you can just let that sink in, and maybe in 3 weeks we could talk about it. But that comes into play in terms of how and when and if these cases resolve. There are so many other facts and interesting tidbits, but suffice it to say that if you are injured on a construction site and are engaging in one of the enumerated activities, it is something that if you have any kind of a significant injury, that it behooves you to investigate your rights. An owner states, "My dog never bit anyone before." So why is there an 11-year-old in the hospital with scars and stitches and emotional trauma? Does the history of never biting before protect the owner? Well, let me explain how this works. And it's an actual interesting story about dog bites and how things can work and don't work, especially in our great state of New York. Until about 30 years ago, New York had a dog bite law that was the case in most states. It's called strict liability, meaning that an owner of an animal, and it doesn't have to be a dog, an owner of an animal who is aware of their dangerous propensities is strictly liable for any harm that may occur. Strictly liable means that they're responsible once they know of the dangerous propensities for whatever happens. There's no defenses, is what that means, okay? Now, we also had claims that could also be made in negligence against dog owners and other animal owners for failure to do many things. It's failure to take reasonable care. That's what negligence is, but failure to take reasonable care of your animals in whatever the situation is. Unfortunately, in the 1990s or early 2000s, I can't even remember the case. It's a famous case of the bull case. And I would say it's baloney, but it was a bad case, bad law that was the law in New York for over 30 years that said, okay, well, I won't tell you what the scenario, what the law said, how they changed it. I'll tell you the story, okay? The story is that someone from I believe it was the phone company, comes to a farm to repair phone lines or whatever, and he has to go through the stables where bulls are kept to fix it. So he comes in and he reports in, and they say, go down over there, and that's where it is to get fixed. Now, in one of the pens is, I don't know what his name was, we'll call him Diego, who is a very nasty bull, who everyone knows is a very nasty bull. In fact, everyone stays away from Diego because he's so nasty. The repairman doesn't know about Diego. He just knows there's bulls, and he probably has never ran into a bull in his life. So he's moving along, and he's going, and he's trying to find the cable to fix or whatever. And Diego is loose. Diego is loose. And Diego gets loose and gores the repairman badly, very badly. I mean, severe injuries. And so repairman sues the farm owners for negligence, saying, you didn't warn me. You didn't tell me that Diego was there. And what the holding was is that we don't allow, New York, at least by this holding, does not allow any claims for negligence against animals anymore. What it required was that you had to show that that they knew of his dangerous propensities to attack people. And of course, they denied any knowledge of that. They knew that bulls can be dangerous. Everybody knew that. But this bull had never attacked anyone, and probably because he had never been let out before, or nobody was dumb enough to go in with him. But anyways, that was the law. In his case, that was the highest court in the state, said, too bad for the repairman. Okay. Well, that case was criticized by everyone across the country and in New York for a long time. They started making all sorts of exceptions to the rule because everyone realized it was unfair. And then late last year, they overturned their own decision, saying we're going to go back the way it was, and you can now make negligence claims involving animals, just the way it is in most other states, by the way. So if you have an animal bite case, let me explain how this works. It can be based on strict liability. Part of the problems with strict liability is that the owner of the animal usually knows the most about it, and to be honest, they're not necessarily forthcoming about their animal's propensities. But depending on the scenario of how the accident happens, you can use negligence to make a claim they didn't use reasonable care or didn't provide adequate warnings based upon what they did know. And that doesn't have the same requirements as strict liability. And really the only difference is that in the negligence claim, the defendant can claim that what's called comparative negligence. They can say the injured party was somewhat at fault for causing this incident, which they can't do in the strict liability situation, okay? So now the law has changed. I don't think the insurance companies have quite caught up with it, but there's going to be all sorts of questionnaires and information to ask on these policies now. They have been asking about dog breeds and whatever, and I think given this situation now, these are things that they're going to want to know when you have a homeowner's policy, because there's coverage, and these can be devastating injuries for children, and for adults. They can, give lifelong injuries. I mean, I personally remember when I was a paper boy, I still have a little scar on my finger from a German Shepherd. I'll never forget this dog. He was not a very pleasant dog who attacked me. So, you know, we remember these things. And so you have to be careful with animals in general, dogs, but it can be cats, it can be bulls, it can be anything. You have to always be aware of is that they are animals and that they can be in situations where they are the nicest animal in the world and still come on situations in which they go back to their, you know, prior existence, so to speak, you know, because they are animals and they do have instincts that can become very dangerous. So the truth now is, though, is that if you are injured by an animal, the theories and the ability to recover are now expanded. The real issue then becomes are the owners of the animals insured, which is a different discussion for a different time because renters, which are a notorious situation with animal bites, particularly dogs, don't normally have renter's insurance. So can you bring a claim against the landlord for a tenant who has a dangerous dog? The answer is yes, possibly. You'll have to show that the landlord knew or should have known the dog was dangerous and had a reasonable opportunity to do something about it. Those are not simple cases. They're very factually complex, and they're really not a situation that you really want to be in. But sometimes the situations are so egregious that renters have such dangerous dogs that the landlord had to know and should have taken steps to ensure the other tenants or nearby members of the community were safe. So that's something I think is it's still the biggest if out there, and it's why you always have to be aware of dogs in adjacent neighborhoods or in adjacent homes, because there's never a guarantee that there's going to be a safe animal and or adequate insurance. Every one of these stories started the same way. Something unexpected, something unfair or very unfair, something that changed someone's life in a moment. In every case, the difference wasn't just the injury, it was what they did next. Because the law is there to protect you, but only if you know how to use it. Thanks for joining me today. I'm Joe Stanley, and that's the law.
Here at Stanley Law Offices, our approach is a little bit different than other law firms. Immediately when you call our firm, we're on it. The paralegal reviews the case with an attorney, we review the case, and then we see right then and there if this is something we can help you with or not.
Each case is different, so it's important to understand the nuances. Each person is different and they require different needs, so it's important to evaluate what those needs are, see if the client has any questions or concerns to ensure that they are addressed in a timely and efficient manner. Stanley Law, the maximum award, people.